Hi, I'm Gidon Kangasa, a lawyer in Litigation and Dispute Resolution Group here at McCabe Curwood. In January, the federal court sent shockwaves through the franchise sector as the ACCC was successful in its claims against Ultratune for breaches of the mandatory franchising industry codes and the Australian consumer law. The court imposed a $2.6 million penalty on the national franchisor for its misconduct. To assess the alleged misconduct, the federal court addressed Ultratune's misconduct in two parts. First, Ultratune admitted to breaches of the franchising code by failing to maintain and update 4 of its disclosure documents, failing to prepare its 5 different financial statements concerning its marketing funds, failing to provide franchisees the financial statements, and failing to provide a disclosure statement when requested by a franchisee. Ultratune were also found to have failed to provide sufficient detail in its financial statements as required by the code. The second part of Ultratune's misconduct involved its dealings with the prospective franchisee, Mr. Ahmed. Ultratune made several false or misleading representations during its negotiations with Mr. Ahmed for his potential purchase of a Parramatta franchise, including the misrepresentation to Mr. Ahmed that his $33,000 deposit was refundable. Ultratune also failed to provide him with disclosure documents when requested. Unsurprisingly, the court called for a need of an increased deterrence given Ultratune's committal of the most serious and fundamental breach of the franchising code, being its failure to act in good faith. To further worsen the case, the court found that Ultratune manufactured evidence in an attempt to cover up its misrepresentation about the refundability of Mr. Ahmed's deposit. In terms of calculating the fine, the court found it to be reasonable to fine Ultratune for its contraventions of the code for each of the disclosure documents, financial statements, and other breaches, at a maximum penalty of $54,000 for each breach. However, the bulk of the penalty came from breaches of the Australian consumer law. So why is this case so important? The federal court's message is clear. Franchisors' misconduct of the code and the Australian consumer law will not be tolerated, especially if franchisors attempt to cover up their contraventions. The ACCC's success came at no real surprise, given that the Commission have increased its appetite for investigating misconduct in the franchising sector. The ACCC have also succeeded recently against the GeoWash franchise. Finally, franchisors should take note that just last month, the chairman of the ACCC warned the franchise sector about the number of serious allegations the Commission have received concerning misconduct. Unless franchisors clean up their act, the ACCC will continue to chase misconduct. If you'd like to find out more information about this area, please contact the Litigation and Dispute Resolution Group.